Hello and welcome. I'm Michael Worth, Vice President of Sales at ComplianceHR. Thank you all very much for joining our webinar today, a Wage and Hour Annual Report, DOL Developments in 2021 and looking forward in 2022. Today we'll cover legislation, regulation, and enforcement from independent contracting to overtiming and much, much more. For those of you who don't know us, ComplianceHR is a unique joint venture between an artificial intelligence platform, Neotologic, and the powerhouse employment law firm Littler Mendelson. Our suite of applications is like having Littler attorneys available 7x24 at a fraction of the cost. These self-service applications provide expert advice on employment classification, handbook creation, leave, and much more. If you are not using AI tools in your business, you are at a significant disadvantage. And don't take my word for it. Sign up for our demo and free trial and see for yourself. Our team will teach you how to use these tools and cut you loose in our sandbox for a free trial. We're going to cover a lot of information, but don't worry. We're going to send you the deck afterwards, a link to the audio presentation, and please sign up for our free trial. You can do that at compliancehr.com webinar-demo. You'll see that at the bottom of every slide, and you can sign up anytime during the presentation. We also want to hear your questions, so please use the Q&A box. We'll get to as many questions as we can, and we can send a follow-up as a result afterwards. Well, now, let me introduce our featured speaker and my friend, Tammy McCutchen. Tammy is a former administrator of the DOL's Wage and Hour Division and was a primary architect to the 2004 Overtime Exemptions Regulation. These were the first changes to the duties test in 50 years. She also represented the Chamber of Commerce and helped defeat the 2016 regulation to increase the minimum salary for exempt to nearly $50,000. Her deep understanding of the DOL wage and hour regulations is built into the logic of the ComplianceHR applications. Our joke around the office for years has been Tammy's brain in a box. Tammy is now retired and living in rural Eastern Tennessee, but she still has her finger on the pulse of hot topics and trends in the DOL. Tammy, welcome, and what do you have in store for us today?
Well, thank you, Michael. It's so great to be back, and it's great to be presenting with you. Today, I'm going to be looking at the past and the future of wage and hour. What did we see at DOL's Wage and Hour Division in 2021 on regulations, informal guidance, and enforcement? What do I expect to see happening at DOL in 2022? I want to take this topic by topic, from who is running the show at Wage and Hour Division to enforcement, with overtime, independent contracting, and other notable developments in the middle. Now, to sum it up, and then you can go, I guess, but please don't. The Biden administration had a fast start, but then they slowed down. But I expect to see a faster pace of changes this year, which could be quite painful for employers. Finally, I want to end with some tips to ensure your organization is following what I am now calling the wage and hour ABCs. Always be complying. So important for 2022 as we see more workplaces reopening fully after the pandemic and as DOL revs up into high gear. I want to begin today by looking at wage and hour leadership. Now, in 2021, the agency was run by Jessica Luman. She was the top political appointee at Wage and Hour. She was appointed as the principal deputy on day one of the Biden administration, and then was given the additional title of acting administrator last June. She can continue to serve as acting until David Weil is confirmed as administrator. Now, her background is with unions, most recently in the building trades, just like the Secretary of Labor, and in Minnesota state government. At DOL, she has spent most of her time erasing Trump administration regulations and policies. Now, perhaps the best way you can learn more about her is to read her posts on the DOL blog. Now, her very first talked about the importance of pursuing the double liquidated damages that are available under the FLSA. Other blogs talked about independent contractor misclassification, empowering workers against retaliation, and partnering with worker advocates. It's very revealing. So I guess I should call this slide Back to the Future, or He's Back. Yes, President Biden has nominated David Weil to reprise his role as President Obama's wage and hour administrator. Now, this is an unusual move, as I know of no person who has ever served twice as administrator. And his prior record at Wage and Hour has made his confirmation difficult. Based on his academic writings and his record at DOL, Weil is focused on correcting the low wage and bad labor conditions he sees in so-called fissured industries. He wrote a book about it. That's what he teaches on in his current job. That is, what that means is industries that rely on employees of other businesses to perform their work. So franchising, independent contracting, and contracting with small businesses are on his naughty list. Now, Weil was initially nominated in June of 2021, but he did not get confirmed last year, so his nomination was sent back to the president. He was renominated in January, and the Senate Labor Committee voted on January 13th to go ahead and send his nomination on to the full Senate for confirmation. The vote in the committee was 11-10 along party lines. One Republican senator, Rand Paul from Kentucky, was not at the hearing. Had he been there and had he voted, we would again have stalemate over David Weil. But I think his fate is still uncertain, as he has a Senator Manchin problem. Yes, as you see, during his first time as administrator, he led a multi-year enforcement initiative against the fossil fuel industry in West Virginia and Pennsylvania. I have on your screen some excerpts from a press release that he did on that initiative. So although many workers in this industry are represented by unions and highly paid, Weil insisted on double liquidated damages to settle most of those investigations. He also made some very negative statements in this press release about the oil and gas industry. Now, like many votes in the Senate these days, unless Senator Manchin votes yes on Dr. Weil, he cannot be confirmed. Now, targeting the West Virginia oil and gas industry is not a way to win Senator Manchin's vote. On the other hand, I don't think my predictions for 2022, which we'll talk about today, would be that much different under David Weil than under Jessica Lumen. A matter of intensity, perhaps, but really no difference in approach. One last, before we go on into regulations, just by the way, this slide shows the number of months it took the Senate to confirm the last 4 administrators. I'm happy to say it was just 3 months for me back in 2001, but 16 months for Cheryl Stanton in the Trump administration, and 8 months for Weil during the Obama administration. He is now in his 9th month since his initial nomination, so nothing unusual yet. We'll see if it takes for him as long as it took for Cheryl. All right. On to substance. Let's first talk about regulations. First, joint employment. Now, remember the Trump regulations? It was a 4-factor balancing test looking to whether the alleged employer hires or fires employees, supervises and controls the employee's work schedule, or conditions of employment to a substantial degree, determines the employee's rate and method of payment, and maintains the employee's employment records. By the way, guys, I know I'm going really fast, but don't worry, you'll have the recording, you'll have my slides so you can go back and review. Now, this Trump administration regulation was effective only from March to September in 2020. That was when it was invalidated and enjoined by a New York trial court. The appeal of that decision was still pending before the Second Circuit Court of Appeals when President Biden was inaugurated in January. Now, last March, the Biden DOL published a proposal to rescind the Trump rule, and that rule was formally rescinded last September. So no more joint employment rule. Well, you should care about joint employment just in case you were joining out, because your company is liable not only for your own company's violations, but violations by other companies found to be your joint employers. Now, temp agencies are a good example, but you could, in fact, be a joint employer with any company with which you have a business relationship. So what is next in this space? The Biden DOL did not replace the Trump regulations last year, and it's not on the regulatory agenda for this year. However, I think there is some chance for informal guidance during the year. Now, remember, during the Obama administration, Weil issued an administrator's interpretation on joint employment, which the Trump DOL withdrew. It's no longer on the DOL's website, but you can find it on the internet. And I put the URL for one place where I found it on the internet for you in case you want to read it, and I do suggest that you do, because this was Administrator Weil's views on joint employment back in 2016. So you would expect that when he's confirmed, or maybe even sooner, the wage and hour could go back to that guidance, although they have not done so yet. My advice to you here is to try to go ahead and read this old administration interpretation and try to comply with it until we get something new. All right, independent contracting. A little bit of a bigger, higher profile issue. The Trump administration also issued a final rule confirming that the test for employee versus contractor status remains the economic reality test, but simplifying the IC analysis by adopting two core factors which DOL said that they would use to make that economic reality determination. That was the nature and degree of control over the work and the worker's opportunity for profit or loss. That took the DOL factors that they considered down from 7 factors to 2, with control over the work really being the most important factor, as it is under the IRS test and the Darden common law tests. Now, this regulation had an even shorter shelf life than joint employment. The final rule was published on January 7th, just 13 days before President Biden's inauguration, with a March 8th effective date. But the Trump rule was withdrawn before it could become effective. Just 16 days after inauguration, the Biden administration proposed first to delay the regulation and then to rescind it. So the regulation was gone on May 6th of last year, having never gone into effect at all. Now, there is still an industry lawsuit challenging the rescission of the Trump rule, and that's pending before a trial court, federal trial court in Texas. I understand it's fully briefed, and I talked to one of the litigators in that case, and they expect a decision on it could come any day. Now, if the judge rules that it was improper for Biden to have rescinded the Trump reg, I guess that means we're back to the Trump reg. So this issue, is really continues to be ongoing. But from a practical standpoint, what are you supposed to do as HR and compliance professionals who have to figure out the policies that your company should adopt in complying with the FLSA? Well, DOL, like joint employment, they did not replace the regulations. And so there are no regulations at all now on independent contracting, right? And there's nothing on DOL's current regulatory agenda, right? They publish a regulatory agenda in the fall and the spring of each year, and this is not on it. So I don't think we will see a new regulation this year. Rescission without replacement of the IC regulation does make your job of compliance more difficult. But once again, I want to point you to an administrator's interpretation that was issued by David Weil during the Obama administration, but withdrawn by the Trump DOL. You can't find this on the DOL's website, but you can find it at the URL that I put on the slide. This letter stated Weil's view in 2015 that, and I'm going to quote this, most workers are employees under the FLSA's broad definitions. So take my advice, read it, share the URL, treat it as law, frankly, whether or not Weil is confirmed. Now, even without new independent contractor regulations, we have seen other changes in this space in 2021. Perhaps the most important was the republication and reposting of Wage and Hour Division's fact sheet number 13, and you can find this online. This was originally from July 2008. It was taken offline with the new Trump regulations, and then it reappeared earlier this year. So this is listing those 7 factors that I mentioned that DOL will consider when determining whether a worker is an employee or a contractor. Now, this is currently the only guidance anywhere on the website from DOL. So really, in addition, read the fact sheet, read that old administrator's interpretation, and together they are your Bible on independent contracting. Now, I probably need another webinar to go through how DOL has applied these factors in particular cases, but let me say this. In my experience, representing employers in misclassification investigations, DOL puts great weight on factor number 1 on your screen, whether the services are an integral part of the business. I have had investigators find misclassification when this is the only factor supporting employee status. Yes, even when the company exercised no control over the work and therefore would be a contractor under IRS or common law rules. Now, the current leadership at DOL does not think that control should be the primary factor as under the IRS or common law test, or even as a core factor as under the Trump regulations. So that won't protect you. You can review fact sheet 13 by going to DOL's new misclassification website. The URL for that is on your screen, together with some screenshots. Any business with independent contractors needs to spend some time on this website. You can learn DOL's views on the myths about misclassification, and you can get the facts on misclassification. You can actually also view a little video called Know Your Rights, all of course written to help employees rather than employers. But also very helpful, I think, to employers is this new chart from DOL comparing an employee with an independent contractor. Surprisingly, believe it or not, I agree with a lot of these. And if you go back and view my last Compliance HR webinar or Tammy talk on independent contracting, you'll see that I see red flags hit on many of these. Paying a contractor by the hour, prohibiting the contractor from working for other companies, being the contractor's first or only customer, engaging the contractor for full-time work over a long period of time, controlling the work. I also want to add to the no-no list, engaging contractors to perform the same work as your employees and treating contractors like employees. So if you have a lot of independent contractors, you really still need to be paying attention to this issue. All right, one more Trump regulation on the early chopping block was tip credit. Okay, I know you don't have tipped employees, and so now you're going to turn out rolling your eyes. But wait, there's something under this for everybody. Believe me, stay tuned. The Trump regulations were published less than a month before Biden took office. And what they did was eliminate limits for the time that tip credit paid employees spend performing work that does not directly generate tips. Previously, DOL had limited such work to 20% of weekly hours. That was known as the 80-20 rule. There was lots of litigation, lots of controversy. Now, the Trump rule never went into effect because the Biden administration first delayed that March 2021 effective date and then proposed a replacement rule. And the new final rule, the Biden rule, I'll call it, became effective at the very end of last year, December 28, 2021. I'm going to pause here. Has any of you ever serve in a political administration as a political appointee? Lesson here, do not wait for the freaking last minute to get your regulations done. My regulations were done in 2003. And they had a whole year to be embedded in for litigation to go on. So what you see here is just time after time regulations that the Trump administration went final near the end of the administration, and they got reversed. They should have done it a lot sooner. They should have started sooner. Unfortunately, of course, they didn't have a confirmed administrator because it took them so long to confirm Cheryl Stanton as administrator. So these new rules have two parts. One of them is just relevant to employers who have employees that you pay less than minimum wage and taking credit for their tips. Now, the Biden rule reinstated that 20% limitation on tips supporting work. Also, tips supporting work is limited to no more than 30 continuous minutes on any day, any time. So any time worked beyond these limits, more than 20%, more than 30 continuous minutes, must be paid at the full minimum wage without taking the tip credit. Now, tip supporting work is newly defined in these regulations as work in preparation of or assisting the tipped producing customer service work. Now, the rule includes examples of such work. I put some of those up on your slide for servers, refilling salt and pepper shakers, rolling silverware, folding napkins. There's also a long list of different examples for like bartenders and busboys, etc. Now, if they, so some of them are on your slide, but not all of them. So I do encourage, if you have tipped employees, you really need to read this new rule. Bottom line here, if a server spends 35 minutes rolling silverware, then you owe him for 35 minutes at the minimum wage, the difference between the tipped wage you're paying and the minimum wage. So you need to now closely control the amount of time that your tipped employees spend performing non-tip producing work. Yep, get out your stopwatch. Or just begin or assign these types of tasks to others who aren't paid on a tip credit. Of course, I know this is a editorial comment here with rising wages and the labor shortage. You just might consider not using the tip credit at all, which is what, by the way, really the worker advocates are after. To learn more about tipped work, because I don't have more time to spend on it today, go to dol.gov/agencies/WHD for wage hour division /FLSA/tips. And there's a whole page on paying tip credit employees. The other part of the tip credit redo was a separate final rule by the Biden administration on civil money penalties. Now, this is the one that affects all of you. But it also may have gone under the radar because it was part of tip credit. It withdrew a Trump provision in the tip credit regulations that civil money penalties that can be assessed by DOL in addition to back wages, civil money penalties, were only available for tip credit violations that were repeat or willful. Now, these penalties are available for any tip credit violation, whether or not it was willful. But the more important part of the regulation expands the definition of what is a willful violation. Now, putting aside tip credit, these civil money penalties are only available for repeat and willful violations of overtime and minimum wage provisions and child labor. Also, if your company is found willful, you will be paying 3 years of back wages rather than just 2. And finally, DOL is far more likely to assess those double liquidated damages, double of back wages, if they find your violations are willful. Now, these regulations define willful as a company knowing its conduct violated the FLSA, but also showing reckless disregard for that FLSA requirement. Reckless disregard is now defined to include failing to adequately inquire into whether the conduct complied with the FLSA. What does this mean? It means DOL expects you to know your company's pay practices, ask questions, and take action to make sure your company complies with the FLSA. Now, this is your return on investment for a compliance program. Employers will always pay 100% of back wages for 2 years. But without a compliance program, DOL is likely to assess a 3rd year of back wages and then double the back wages as liquidated damages and civil money penalties, which are currently up to over $2,000 per employee that you did not pay correctly. Now remember, I designed the ComplianceHR's applications on independent contracting and overtime and others. I think there is a good chance that being able to tell DOL when they come knocking on your door that you used an app designed by a former administrator may help to limit your liability to those 2 years of back wages rather than the equivalent of 6 years of back wages. And that is a 2/3 savings. You really need to do compliance now. And my instinct on this is borne out by press releases that I've been reviewing. I get emails, you can sign up for them too, that I get all the press releases that Wage and Hour issues. And I don't recall seeing one in the last year where there was not double damages imposed. So DOL is on the warpath. They do not think it's enough that violators of the FLSA just pay the back wages they should have paid in the first place. They want you to pay double. And this is the regulation that's going to allow them to do that if you do not have a compliance program. All right, now I really don't have time to talk much about government contracting, but some of you out there may be government contractors, so let me do this quickly. And there's something in here too, a development that's important even if you don't think you're a government contractor. So in November, DOL published a final rule raising the minimum wage for government contractors for $15 per hour. That is, of course, what they can't get through Congress because Park Senator Manchin doesn't support a $15 minimum wage. Although, by the way, he has stated that he would vote for an $11 minimum wage. So, and this was, of course, one of President Biden's first executive orders was called on DOL to impose a $15 minimum wage on government contractors. Now, interestingly, it was followed up in December. After they issued the final rule, DOL followed up in December with a new field assistance bulletin, which further defined the scope of covered contracts, who exactly is covered by this $15 minimum wage. And in short, both the final regulations, but even more the executive order, and even more this new field assistance bulletin are very, very broad. If your company receives any money from the federal government, directly or indirectly, you probably have a $15 minimum wage obligation. Now, I know with inflation and increasing wages, you see a lot of advertisements, even for fast food franchisees, that they're paying much closer to $15 minimum wage, even here in rural Tennessee, than we saw a year ago. If this can apply, for example, if you are a retailer and you have a store on a military base, the employees in that store could be entitled to this $15 minimum wage. So, and that's called you're being at concessions, or it covers concessionaires, it covers subcontractors, and it's going to cover anybody who gets any money from the infrastructure bill. So be ready for it. One other item on DOL's regulatory agenda includes an entry to modernize the Davis-Bacon Act. So right now there's just two items on the regulatory agenda for Wage and Hour: overtime, which we'll talk about in a minute, and Davis-Bacon. Now this could be a massive and comprehensive rewrite or even just a few tweaks. Nobody that I have talked to, I have some friends in the Associated Builders and Contractors organization, and nobody really knows what is going to be in these regulations. But what we do know is that DOL has drafted a proposed regulation on the Davis-Bacon Act, and that proposed regulation was cleared by the White House last week and could be published any day, any time. The regulatory agenda, in fact, does state that the proposed rule will be published this month. So if you're a government contractor, keep your eye out for that. Finally, overtime. So the white-collar exemptions, as I said, are back on DOL's regulatory agenda, which doesn't surprise me at all. The regulatory agenda lists a publication date for proposed regulations in April. Now, these dates do tend to slip. They are more aspirations than deadlines. Interestingly, of course, the regulatory agenda says one of the primary goals of this rulemaking would be to update the salary level requirement. And that's not a surprise. I'd be really surprised if we didn't get a salary level increase. But it says one of the primary goals. So changes to the duties test for exemption are not off the table. Now, the duties tests were last changed in my 2004 regulations, and all the shenanigans between 2004 and 2020 were only about the salary level test. So I would be shocked if we do not see an increase in the minimum salary level for those overtime exemptions. But the question is, how high will they go? Now, the chart on your screen gives you a bit of history. The Obama DOL raised the minimum salary in 2016 from my 23,660, which was set in 2004, to 47,467, using a methodology which looked to the 40th percentile of salaried workers in the South Census region. Now that increase, as you recall, that 47,467, unless you're really young, that increase was invalidated by a Texas court, and then the Trump deal, and then of course before the appeal of the district court's decision to invalidate that Obama reg, we had the President Trump was inaugurated, and the Trump DOL redid it. So they did a new regulation, as you'll remember. This was in 2019, 2020, and they brought us to that 35,568, which it is today. That's the minimum salary level you must pay employees if you're not going to pay them overtime. They, instead of the 40th percentile, they used a methodology that we used in 2004 of the 20th percentile in the lowest salary states. Most of those are in the South. Now, my prediction here is that the Biden DOL, when I want to go back to the Obama standard, why wouldn't they, using that 40th percentile? Now, we don't know how much, I have not done the math, so I don't know how much the 40th percentile would be. And they do have the problem with the Texas decision, which is still on the books. And that court invalidated this 40th percentile methodology. It's still out there. But consider this. If we adjust the 2016 Obama level for inflation, we are almost to 68,000. I think we can certainly expect a salary level that tops 50,000. The table on your screen shows the projected salary level under the Obama standard as projected by the Employee Advocacy Group, the Economic Policy Institute. EPI has been my on the other side of this issue for many, many years, and it's something that both the Obama administration and the Biden administration will pay close attention to. Now, obviously, this is a topic that needs its own webinar, and we will bring that to you just as soon as we have a proposed rule. Could be in April, could be in May. But for now, I think I'm done with regulations. I need a break from talking, however, and I want to hear from you. So I'm going to turn the mic back over to you, Michael, and I think we're going to do a poll.
Yes, we are going to do a poll. That's a lot of information to process right now. So Diane, please start the poll. What we'd really like to try to understand is, what is keeping you up at night? Is it joint employment, independent contracting, tipped employees, civil money penalties, government contracting, or overtime? You know what I love about working with Tammy is we've got over 1,700 people on this webinar. So listening to what's important to you will certainly give us good feedback on the things that are keeping you up late at night. Tammy, if you were, a betting person, which I know you are, would you have any insight on what you might expect here?
Well, I think most people are going to say overtime. That would be my guess, because that affects most of us. And it'll be very interesting, though, because with inflation, and we are seeing wages rising. The question is, to me, is an increase in the salary level actually going to hurt? Maybe I should have done that as a separate polling question. I think, but I'm expecting it. As I said, and I'm expecting it'll be over 50,000, and I think it'll be very hard to say that that's too high. Nobody thought we would win that case in 2000 to stop the 2016 increases, Michael. They thought we were crazy to file, and it was a surprise that we won. I don't think it's going to happen again, unless, of course, they go way over, right? If they go way over the top, if they try to go to 70,000 or even 60,000, I think they'll have a problem. But if they go around 50,000, I think it'll hold given inflation that we've seen in wages of late.
Okay, so we're going to go ahead and we're going to shut the survey down. We'll give you a chance to answer your questions in 5, 4, 3, 2, 1. And I guess, Tammy, maybe because you gave people insight to your feelings, but it certainly looks like overtime is really on the top of people's minds based upon the results we got. And again, I love having such a great audience to pull from. When you have hundreds of people expressing their concerns, it certainly is a good indication of what's to come. Any other comments or feedback that you would want to apply here, Tammy?
I'm not surprised, but if you have tipped employees or you're a government contractor, you really need to pay attention to those issues too. Like particularly for tipped employees, the litigation is coming, Michael, on that, because now there's going to be litigation on whether or not a particular activity is tip supporting or tip generating, and how much time are your employees spending rolling the silverware and refilling the salt and pepper shakers? Was it 30 minutes, or was it 28 minutes? Or was it 32 minutes? And so litigation is coming, so that's a really big compliance area for me. And independent contracting is still a big, huge compliance issue.
But,
all right.
Folks, we've had a number of folks sign up for a free demo and free trial. We'll follow that afterwards. If your number one area of concern is overtime, we have tools that will help you identify that risk very quickly. So don't be shy. At the bottom of each slide is the link to the independent contractor or the free trial, and you'll see it at the bottom of the next slide, and I'll pass it back to you, Tammy.
Thank you. So that's it for the regulatory landscape. I'll answer one question now. Are the IC guidelines that were in effect previous to Trump guidelines no longer in force? Well, it's very unclear, but I think they are enforced. I think you can go back to the Obama administration's, I would go back, as I said, and look at that independent contractor administrator's interpretation that Weil signed in 2015, and that should be your guidelines. Okay, so there are, outside of the regulatory landscape, however, things were slower in 2021, but there were still some informal policy changes and guidance in 2021 that you really should know about. The Biden administration quickly withdrew 3 opinion letters, 1 involving the tip credit and 2 involving independent contractors. Now, the press release on this stated that these letters were issued prematurely because the tipped employee and the independent contractor regulations were not yet final. Now, one of these opinion letters is really big. It's an opinion letter that I actually helped the industry obtain. It was about the gig economy and whether gig companies that have the marketplaces have employees or independent contractors. These are the drivers, for example. And so that was what DOL said, no. Drivers and other companies that provide marketplaces to connect contractors with consumers are not, they're contractors, not employees. That was withdrawn, but it hasn't been replaced, so we're sort of up in the air. Now, I can see DOL moving to reverse and hopefully replace other opinion letters, but only time will tell. Now, in a webinar that I did last February, I don't know if anybody was on that, I did predict that DOL would stop issuing new opinion letters. Recall that the Obama administration did not issue opinion letters at all, and they're very helpful for employers because following an opinion letter or getting an opinion letter can be a good faith defense against liability. So the Biden DOL has not made any announcements about opinion letters. They have not stated that they're not going to issue opinion letters, but no new opinion letters were issued in 2021 or in this year. So we've had 14 months now with no new opinion letters. Now, this is where, for example, get your demo. ComplianceHR's Policy Smart app can be a fabulous help for you so that you can keep up with new developments since they're not on opinion letters anymore. Also, the paid program. Opinion letters, I think I can call them gone. Also gone is the paid program. Now, do you remember that? That was the program where employers could voluntarily report and correct FLSA violations and pay 100% of violations. But as good faith employers, you paid only 2 years and you were not assessed the double liquidated damages or civil penalties that I talked about. Now, this was the first program of the Biden administration ended. It was ended by a press release on January 29th, 2021, stating that the program, I'm going to do some quotes here, deprives workers of their rights. So paying back wages, 100% for 2 years, deprives workers of their rights. And the DOL will use all enforcement tools available. In other words, they don't want just 2 years of back wages. They want 3 years plus double. So I'm also concerned, and I'm going to predict, that it's going to be very difficult for employers to get help from the Wage and Hour Division when you're struggling to figure out whether a pay practice complies with the FLSA. The thing DOL now says you have to do in order to avoid a willfulness finding, to avoid the third year of back wages and double damages, is that you have to ask questions. Well, it's going to be tough to get answers out of DOL. Why? Well, I'm looking at a blog post by Acting Administrator Jessica Lumen. She's the political point who's in charge, as I just said. It was from less than a month ago, on January 19th. The blog describes 70 listening sessions, which allegedly both workers and employers around the country. So they did 70 of these listening sessions all around the country. And the lessons that WHD, the Wage and Hour Division, learned from the listening sessions, none are about the help employers need. Workers, not employers, need to know how they can come to Wage and Hour for help. The Wage and Hour Division needs to reach workers, not employers, about independent contracting. Wage and Hour needs to collaborate and connect to workers and advocates, not to employers. Now, if I'm wrong about this, I wish Jessica Lumen would blog about the importance of helping you, the employers, as you're trying to figure out what policies and practices you need to adopt to comply with the FLSA. Now, with no opinion letters and with no compliance assistance, what can you do and where can you go for help? Now, I guess the best option is to hire an expensive Wage and Hour attorney like me. But I do have some suggestions if you can't afford the $400, $500, or for me, yes, $750 an hour for my advice. I have two suggestions. One, of course, get a ComplianceHR subscription. And two, call your local Wage and Hour Division district office. Talk to a career assistant district manager or district manager. These are folks that have been at Wage and Hour for long enough to be expert at the FLSA, and they should be much more willing to help, much more willing to answer your questions. They're less likely to have a political axe to grind. So on the screen, I did put the URL where you can find the names and telephone numbers of the assistant managers and district managers. Call the local numbers listed on that page. Don't bother calling the toll-free number, that 8664 US wage number, because you're just going to get standard responses for that. So call the local office numbers and talk to somebody at your local office if you have an answer. Now, I will tell you that you'll get answers, but by the way, those answers are not. Can you rely on them? Well, you can rely on them in the sense that you're going to know what you need to do. You're going to have information about what's better to do. However, the political leadership in the national office of DC may or may not have the same view about anything. All right, two more developments. Arbitration agreements are out. And as we've been talking, liquidated damages are in. Now, it's very unusual for the Wage and Hour Division to issue a press release on a district court case. But last September, they got a very important ruling, and they put out a press release. And in this case, the court found that DOL has independent authority to seek back wages for employees with arbitration agreements. Count this one as a policy change. Wage and Hour will not stop an investigation because your employees have arbitration agreements. Right? So even if you have arbitration agreements, class action waivers that cover wage and hour claims, DOL doesn't care. If they get a complaint, they're going to go after it, and they can impose back wages on a class-wide basis, and they have a district court case in New York that tells them that they can. In other good news, this is another Jessica Lumen blog from last April. She announced that she would be seeking those double liquidated damages pre-litigation in order to settle investigations. So if you want to settle rather than litigate, you're going to have to pay double damages. Now, my question on that always was, well, if I'm going to have to pay 3 years plus double damages just to settle, why wouldn't I litigate? Maybe I'll win. You know, maybe DOL's position on the FLSA is wrong. And if I'm not going to get any discount for settling, there's no incentive to settle. But we'll see how that goes. And that sort of brings me to enforcement because, you know, I think it negatively affects settlements. I think less employers are willing to settle. And I think that has an effect that is contrary to what the Biden administration would actually want in terms of settlements. So I just filled your day with joy today, I know, but I have this one last topic before I can give you the compliance tips. So let's talk about enforcement. So the Wage and Hour Division recently released its fiscal year 2021 enforcement statistics. That's the back wages collected from October 2020 to September 2021. I'm sure they must have been a bit disappointed as back wages collected have continued to fall this year. They collected only $234.2 million in back wages, which is $23.6 million less than in 2020. And that was the year, you remember, when many businesses, especially in restaurant, retail, hospitality, were closed for much of the year due to the COVID pandemic. Now, if you compare 2021 to 2019, the last year before the pandemic, back wages collections are actually down $90 million annually since the pandemic began. And yes, in case you're wondering, you're reading my blues and reds correctly. In my chart, President Trump's DOL collected more back wages than Obama or Biden. And if you don't believe me, you can check on the DOL's website. It's dol.gov/agencies/WHD/data. Now, David Weil's best year, in his best year, he collected just $265.5 million, and that was in 2016. So, good news, right? With enforcement dropping in the last 2 years, isn't that good news? Why should you bother with compliance? Well, remember, please, that the drop in 2020 was largely due to the pandemic. And some of that was probably left over in 2021. Also, historically, we do see a decline in back wages collected during the first year of a new administration. That happened to me in 2001. Also, more good news. On February 1st, the Wage and Hour Division announced that it will be hiring 100 new investigators, and more than that, depending on appropriations. So watch the budget fights. We've already talked about liquidated damages and supplementary penalties. So more, and more. And that means that there is more trouble coming your way. And just by the way, I prefer to get a seasoned investigator than one of those 100 brand new investigators. Investigators usually come out of the Peace Corps or from state DOLs. Very few folks that become DOL investigators are folks like you who have actually worked in a company and understand the difficulties and the challenges. Frankly, I would love to see everybody on this call go in to usajobs.com and apply to be an investigator, because I think they would have a more talented and reasonable investigation staff if they had some people who actually had worked in HR investigating this. I'm a little bit short on time, so I'm not really going to read this slide, but you're going to get it to review. There is changes in H2b enforcement. So if you have, that's the temporary visa programs for non-agricultural workers. If you use H2b visas, you need to go and read this new Field Assistant Bulletin 2021-3. It's one of the two new pieces of guidance that DOL has published in 2021. And basically what it does is it makes some changes, which I'm not really sure they have authority to do, but it makes some changes which makes an FLSA overtime violation into an H2b visa violation, allowing DOL to impose penalties at the H2b max, which is $13,000, rather than the FLSA max, which is $2,000. So with this FAB, DOL has changed the penalties for FLSA overtime violations from $2,000 per employee to $13,000 per employee. So you really, if you have H2b visas, you need to read this, and you really need to pay attention to overtime compliance in order to not get caught. All right. Oh, goody. I do have time. I know we just have 10 questions. We'll get to your questions as soon as I can, but I do have an investigation of the year for you. So I'm going to end the directness with a bit of humor. My investigation of the year is a Georgia repair shop owner who got a bit mad at an employee when he complained to DOL that he hadn't gotten his final paycheck. So the owner paid the employee his final wages of $915 by dropping $91,500 in pennies covered with oil on his driveway. With that little white piece of paper you see, that's the pay stub sitting on top of the pile of coins. Oh, and then the owner made defamatory comments about the employee on his website. So, of course, DOL investigated, and, of course, they found other violations for employees. So the result is that DOL has now sued, seeking almost $37,000 in back wages and liquidated damages. So whether you can actually pay employees in pennies is an interesting legal issue. There's nothing in the FLSA that prohibits it, and coins are, even pennies are legal tender. On the other hand, DOL, the employer's behavior prompted a full investigation by DOL. And of course, the lesson is don't get on the wrong side of DOL, folks, as they can turn a $915 final paycheck bill into almost $37,000 in back wages. Also, please don't take employee complaints personally, folks. And don't get cute when you're paying back wages. All right, just a couple more minutes to talk about my wage and hour, always be complying. And here's what I want to say here. This should be a year for compliance with you. And I know you're coming back to work. Pandemic has been horrible. It is time to get back with the focus on compliance. Now, what do I mean? There are two things here. First, you need to identify the wage and hour compliance issues that may be present in your workplace, whether that's your exemption classifications or off-the-clock work, compliance HR applications, especially Policy Smart, the Navigator OT, Navigator IC can really help with that. And second, you've got to have a formal wage and hour compliance program under these new willfulness definitions. Don't leave compliance to chance. Don't respond to employee complaints on an ad hoc basis. You need to have a wage and hour policies and review them regularly. You should also conduct regular audits of your practices. I recommend every other year. Include your IC classifications, your exempt employee classifications, and take a close look at your timekeeping and payroll processes. Include immigration and government contracting if you are in that space. If you find violations during the audit, for heaven's sakes, correct them. If you find practices that could lead to violations that aren't good practices, improve them. Provide wage and hour training to both managers and employees. Teach employees their responsibilities under your timekeeping system. Teach them that they have the responsibility to accurately report all the hours that they work. Teach your managers your wage and hour policies, your timekeeping and payroll practices, and what it means to work. A couple recommendations here. NavX Global has computer-based wage and hour training. Also, Littler's Legal Learning Group can custom design training for you, either computer-based or live. And SHRM has sample training decks that are free to its members. And of course, always sign up for my webinars, and I'll try to give you as much information as I can. And have a process for employees to complain about their wages. Wage and hour liabilities can be far larger than discrimination and harassment. So you should have the same processes, a toll-free hotline, posters on how employees can complain, investigation procedures, documenting complaints and the investigations and the results. In fact, I'll end there because I really want to get to some questions. Document your compliance efforts so that you can prove to DOL and the courts that you are a good faith employer and that you did not violate the FLSA willfully. Now I'm going to turn the mic back to Michael to discuss how Compliance HR can help you. I think we have another call.
Tammy, thank you so much. So it's that easy, right? Hang on, I'm going to back up again. So all I need to do is identify my compliance issues, develop a compliance program, and off I go. Well, that sounds great, but if you have hundreds of employees in a multi-state footprint, this is a daunting task, especially what's been changing with things like paid sick leave and the regulatory change. We've never seen more changes as long as we've been doing this. So as easy as it may sound, it can be easier if you build or you use the tools in the Compliance HR Navigator Suite. There's over 20 applications that are loaded with federal and state rules, and they're continually updated by Littler. These applications have saved our clients millions of dollars in potential legal fees and non-compliance lawsuits. Understanding risk and using accurate, up-to-date information allow organizations to be proactive instead of reactive. And we're always listening to our clients and prospects. We get our best ideas. And in 2020, we pumped the brakes on it and deviated from our roadmap and quickly created tools to help organizations comply with the COVID-19 regulations. Our Compliance HR Smart Screen application helped bring thousands of people back to work safely amongst these unprecedented times. Along those same lines, we're always looking at how we can make our applications and information and webinars better for you. So I'd like to open up one more survey, please, here. And if you folks would be kind enough to tell us what's most important to you going forward. We'd like to hear from you on what you would like us to put into our next webinar, whether it's creating and updating compliant handbooks or understanding your independent contractor misclassifications. I saw a lot of things on independent contractor and overtime come in questions. So Tammy, perhaps you can answer some of those. And I'll just give folks a few minutes to answer some of these questions. And while we're doing that, please do not hesitate to sign up for your demo and free trial. When you see these applications, you'll be wishing you would have used them sooner. When I get back to the next slide, at the bottom of the banner, you will see the compliancehr.com/webinar demo, and you can sign up there. So please don't be shy. All right, we're starting to slow down a bit, so why don't we go ahead and we can close the survey in 5, 4, 3, 2, 1. And so this will give us an idea of what you might be attending our next webinar on. It seems like, again, handbooks has been so popular. Our handbook product, Policy Smart, has been our #1 application for the last 2 years. So we will take this information and we will use it to help create our next webinar. So thank you so much for sharing all that. All right, Tammy, we've had a number of great...
Yeah, and let me tell you one thing about policy. I once did that for a major retailer, and it cost us, I think we spent like $2 million, right? And now we have it all built into an app. So you always know that your policies are up to date and compliant in whatever state that you have employees. So that's an amazing app. 2 questions, Michael, that I've seen that I want to ask real quickly, and then I know you have a couple that you have on your list. We have a question from somebody who has tipped employees, wondering whether what I meant was that 2 hours out of 40 of folding napkins means you owe them minimum wage. And no, that's not true. It's either over 30 consecutive minutes any day, any time, or 20% of all work hours in a week. So that means the tolerance for somebody who works 40 hours a week, that means the tolerance is 8 hours a week. So if somebody's folding napkins more than 30 minutes at a time, or a total of over 8 hours in a week, you're going to owe the minimum wage. And here's a really important one, Mike. Are you protected from IC and joint employer allegations if you're using a managed service provider, a professional employer organization, or something like that? In other words, there's somebody between you and the employees. Legally, no, right? Because you're going to be, if you have employees from a temp agency, from a PEO, I think this DOL especially will find that you're a joint employer. But what can you do, right? Make sure that, first of all, make sure you're using an organization that has some assets, right? It's going to be there when the worker files a wage and hour complaint, and that they're going to be responsible for. So when you're signing up, whether it's a temporary employee agency, whether it's a professional employee organization, whether it's a management service provider, make sure you have a good indemnification clause in the contract that they're going to be responsible for both the legal fees and any judgments if they're not treating their employee correctly as an employee.
All right, we are at the top of the hour. No, that's a great one. But you talked about it, and I've seen some questions come up about what do you expect the enforcement to increase, and what industries do you expect to have the most impact on?
Yes, I do expect it to increase. Now, you might see it go down a little bit as they're training the 100 new investigators, but I think we can learn a lot from those press releases that I said. And in preparing for this webinar, and I see people are still hanging around, so we still have 1,300 people on. I reviewed every press release that the Biden Wage and Hour Division has released. From that, I conclude that the top issue for them will be independent contracting, but also I'm seeing a good number of press releases on federal contracting, on off-the-clock work, and even the regular rate. That's when you fail to pay overtime on your bonuses. There's been a lot of press releases showing back wages for that. As for industries, based on both the 2021 enforcement data, which is on the website, and those press releases, I think the top industries that are in the crosshairs of DOL are construction, food services, healthcare, and retail. I'm also seeing a lot of press releases on grocery, on home care. Oh my God, so much on home care, on restaurants. So, but please don't ignore compliance if you weren't in my list of industries, because they're going to go after everyone. But if you're construction, restaurant, retail, home care, grocery, you really need to be concerned.
Well, we are out of time. Again, if you haven't signed up yet, compliancehr.com/webinar demo. Please work with us. We will get you up and running to use some of these tools to help understand where your risk lies. Tammy, thank you so much. It's always a pleasure to work with you and listen to your insight. And ladies and gentlemen, thank you so much for attending our webinar today, and we hope to talk to you again in the near future. Everyone have a wonderful day. Thank you.